This is the LWA Contracts Third Party Problems Audio Outline. Things we will cover: third party beneficiary, assignment, delegation. Third party beneficiary. Which third party beneficiaries can sue? Intended versus incidental beneficiary. Only intended beneficiaries can recover. Incidental beneficiaries do not have any rights. Test. To whom is performance to be given according to the language of the contract? Said differently, was the purpose of the promisee, according to the language of the contract, to get the benefit for herself primarily or confer a right to another directly? Factors to consider whether intended beneficiary. Courts look at the following factors to help resolve whether a beneficiary is intended. 1. Is the third party expressly designated in the contract? If so, it is more likely that it is primarily for her benefit. 2. Is the performance to be made directly to the third party? If so, it is more likely that the contract is primarily for her benefit. 3. Does the third party have any rights under the contract? If so, it is more likely that the contract is primarily for her benefit. And 4. Does the third party stand in such a relationship to the promisee that one could infer that the promisee wished to make an arrangement for the third party's benefit? If so, it is more likely that the contract is primarily for her benefit. Creditor or donee beneficiary. If the beneficiary is an intended beneficiary, you must also determine whether it is a creditor beneficiary or a donee beneficiary. Creditor beneficiary. A third party is a creditor beneficiary if the promisee's primary intent in contracting was to discharge an obligation he owed to a third party. Under the majority view, it is sufficient that the obligation is real or merely supposed. Donee beneficiary. A third party is a donee beneficiary if the promisee's primary intent in contracting was to confer a gift on the third party or create a right in the third party, irrespective of motive. When do the rights of the beneficiary vest? An intended beneficiary can enforce a contract only after her rights have vested. This becomes important when the original parties to the contract take action, e.g., rescission, modification, etc., that can affect the third party beneficiary. The general rule for both creditor and donee beneficiaries is that their rights vest when the beneficiary 1. manifests assent to the promise in a manner invited or requested by the parties, 2. brings a suit to enforce the promise, or 3. materially changes position in justifiable reliance on the promise. What are the rights of the promisee and the third-party beneficiary? Third-party beneficiary versus promisor. The third-party beneficiary may sue the promisor on the contract. The promisor can raise any defenses against the third-party beneficiary that he could have raised against the promisee. Third-party beneficiary versus promisee. Creditor beneficiary. A third-party creditor beneficiary may sue the promisee on the existing obligation between them. Donee beneficiary. A third-party beneficiary may not sue the promisee because the promisee's act is gratuitous. Promisee versus promisor. Donee beneficiary. At common law, donee beneficiary had no cause of action against the promisee, so there was no damage suffered. Please see the exception. At common law, a promisee cannot sue a promisor for non-performance to a donee. Majority view. Modernly, the promisee does have a cause of action against the promisor. Most courts resolve this situation by granting specific performance. Creditor beneficiary. Where a creditor beneficiary is involved and a promisee has had to pay the beneficiary on an existing debt, the promisee may recover against the promisor. If the debt has not yet been paid by the promisee to the third party, the promisee can compel the promisor to pay in a specific performance action. Assignment of rights and delegation of duties. The basic fact pattern. X enters into a contract with Y. This contract does not contemplate performance to or by a third party. Subsequently, one of the parties seeks to transfer her rights and or duties under the contract to a third party. Assignment. An assignment is a transfer of rights under the contract. Things to know. What rights may be assigned? What is necessary for an effective assignment? Is the assignment revocable or irrevocable? What are the rights and liabilities of the various parties? What if there are successive assignments to the same rights? What rights may be assigned? General rule: all rights may be assigned. Exceptions: rights that cannot be assigned. If an assignment of rights would substantially change the obligor's duty or obligor's risk, the assignment will be barred. A right may not be assigned if it is prohibited by law. Limitations on assignment. Determine whether the contract provision prohibits assignment or invalidates assignment. Limitations on assignment. Prohibition. Here, the contract provision will prohibit assignment. You can't make an assignment. All assignments are prohibited. Rule. Language of prohibition takes away the right to assign, but not the power to assign. This means the assigner is liable for breach of contract, but an assignee who does not know of the prohibition can still enforce the contract. Limitations of assignment, invalidation. Here, the contract provision will indicate that any assignment is invalid. All assignments and rights under this contract are void. Any assignment under this contract will be invalid. Rule: language of invalidation takes away both the right to assign and the power to assign. Result: there is a breach by the assigner and no rights held by the assignee. Requirements for an effective assignment must be language of present assignment. Assigner must manifest an intent to transfer their rights under the contract completely and immediately to the assignee. General rule is that consideration is not required. Writing not required except in 4 situations. 1. Wage assignments. 2. Assignments of an interest in land. 3. Assignments of cause of action worth more than $5,000. And 4. Assignments intended as security interests under Article 9 of the UCC. Gratuitous assignments. Assignments made without consideration, also called a gift assignment. Generally, however, such a gift assignment can be freely revoked. Revocation can be accomplished directly or indirectly by 1. Bankruptcy. 2. Death. 3. Notice of revocation communicated by the assignor to either the assignee or the obligor. 4. The assigner taking performance directly from the obligor. Or 5. The making of another assignment. Is the assignment revocable or irrevocable? If the assignment has been given for consideration, it is irrevocable. An assignment not supported by consideration, a gratuitous assignment, is generally revocable. Exceptions: a gratuitous assignment is not revocable if 1. It is the subject matter of a writing delivered to the assignee. 2. The assignee has received some sort of indicia of ownership. Or 3. The assignee has relied on the assignment in a way that is reasonable, foreseeable, and detrimental. The problem of multiple assignments. Where there are multiple assignments, the issue will be who has the rights. The key is determining whether it is an assignment for consideration. Where there isn't consideration, meaning it is a gratuitous assignment, the general rule is that the last in time assignee wins unless an exception from the previous slide applies. If it is an assignment for consideration, then the first in time assignee for consideration wins. Very limited exception to this rule: a subsequent assignee takes priority over an earlier assignee for value only if he both 1. Does not know of the earlier assignment, and 2. Is the first to obtain payment, a judgment, a novation, or indicia of ownership. What are the rights of the various parties in assignment? Assignee versus obligor. The assignee is a real party in interest, and she may enforce her rights against the obligor directly. Note that the obligor can raise any defenses against the assignee that he could have raised against the assignor. Assignee versus assignor. The assignor is deemed to give several implied warranties to the assignee, the breach of which will give rise to a cause of action. Note that the assignor will not be liable to the assignee if the obligor is incapable of performing, e.g., is insolvent. Delegation of duties. A transfer of contractual duties is called a delegation. The main issues to know: 1. What duties may be delegated? 2. How does one make a valid delegation? 3. What are the rights and liabilities of the various parties where there has been a valid delegation? What duties may be delegated? General rule: all duties may be delegated. Exceptions: 1. Duties involving personal judgment and skill may not be delegated. 2. Change to obligee's expectancy if performance by the delegate will materially change the obligee's expectancy under the contract. The duty may not be delegated, e.g., requirement contracts, outputs contracts. 3. Contract provisions prohibit delegation or prohibit assignment. What is necessary for an effective delegation? Generally, no special formalities are required for a valid delegation. May either be written or oral. The delegator must manifest a present intention to make the delegation. There are no requirements that the word delegate be used. Any language of transfer is sufficient. What are the rights and liabilities of parties? Obligee must accept performance from the delegate of all duties that may be delegated. Not required to accept performance from the delegate of those duties that may not be delegated. What are the rights and liabilities of parties? Delegator remains liable on the contract. This is the case even if the delegate expressly assumes the duties. Delegate. The liability of the delegate turns largely on the question of whether there is a mere delegation or an assumption of duty. Only liable if the promise is supported by consideration. Distinguish novation from other third-party situations. Novation substitutes a new party for an original party to the contract. This requires the assent of all parties and completely releases the original party. This ends the LWA contracts third-party audio outline.